Hello, welcome to January 2021 episode of My PIP Monthly. My name is Amber Rouse Holloway, and I'm a partner here at our Troy office. Our January 2021 topics will include, of course, the case law update. First, we will discuss the case of the estate of John Corforti by Donna Corforti, personal representative, v. Stanley Webster and Metro Controls. Next up will be Hurley Medical Center v. Farm Bureau. Then Melrose v. Nationwide and Sterling Heights Pain Management v. Farm Bureau as well. And for our trending topics in PIP litigation, we will discuss the recent change of the MAIPF, wherein it agreed that the 2019 auto reform changes of order of priority took immediate effect. First up for our case law update is the estate of John Corforti. The big takeaway from this case is that it expands upon MCL 500-3135-2B and MCL 600-2959 and the issue of when a pedestrian is more than 50% at fault for a motor vehicle versus pedestrian accident. Here, essentially, the court ruled that even though plaintiff violated Michigan law and the Uniform Traffic Code when he crossed a 7-lane highway outside of the marked crosswalk, there still existed a genuine issue of material fact regarding whether plaintiff was more than 50% at fault, since he had been visible in the roadway for a sufficient amount of time to be seen and avoided, and the defendant driver failed to pay attention to the roadway at the time of the accident. By way of background, John Corforti was killed in the motor vehicle versus pedestrian accident. At the time, he was attempting to cross a 7-lane highway outside of the marked crosswalk, obviously in violation of Michigan law and the City of Warren's Uniform Traffic Code. When he was crossing the far right lane of northbound traffic, he was struck by a pickup truck driven by Stanley Cornell in the course of his employment while he was employed with defendant Metro Controls. He was transported to the local hospital after the accident, where he was pronounced dead. Thereafter, his estate filed a complaint alleging negligence and gross negligence against Cornell and Metro Controls. Defendant subsequently filed a motion for partial summary disposition, arguing that the estate was barred from recovering non-economic damages due to the fact that John Corforti was at more than 50% at fault for the motor vehicle accident. Conversely, the estate argued that there did exist a genuine issue of material fact, whether he was 50% at fault. The estate submitted an affidavit from its expert, who essentially opined that had Cornell been paying attention and not been distracted at the time of the accident, he would have been able to avoid the collision. He testified that prior to the impact, he had been paying attention to the right side of the road and not the left, and therefore never saw the deceased. Thereafter, the trial court went on to grant defendant's motion for summary disposition without a hearing and without oral argument. The trial court noted that Corforti had violated Michigan law and the Uniform Traffic Code when he crossed outside of the crosswalk and entered into Cornell's lane of travel. Additionally, the trial court reasoned that even though Cornell had a spare second to swerve and apply the brakes, that fact did not make Cornell equally or more than 50% at fault. The estate appealed the decision, and the Michigan Court of Appeals ultimately reversed the trial court's decision. The court noted that Cornell had a statutory duty to keep a proper lookout and drive at a speed that would permit a stop within the assured clear distance ahead. The court analyzed that the evidence submitted by plaintiff in response to defendant's motion for summary disposition, as well as the deposition testimony available, found that even though Corforti was indeed negligently crossing or attempting to cross the crosswalk outside of the marked crosswalk, he had been visible in the roadway for a sufficient amount of time to be seen and avoided by Cornell. In the case of Hurley Medical Center v. Farm Bureau, the question of whether an injured, uninsured young adult passenger is domiciled for purposes of identifying an automobile insurance policy under which the uninsured passenger may receive benefits. The relevant statute here is MCL 500-3114, Section 1, which states in pertinent part that a PIP policy applies to accidental bodily injury to the person named in the policy, that person's spouse, and a resident relative domiciled in the same household as the person named in the policy. The underlying claimant in this matter suffered severe jaw injuries in an automobile accident on April 8, 2017, which required him to be airlifted from the scene to Hurley Medical Hospital in Flint. After the accident, he returned to his mother's residence to recuperate. He made a claim for PIP benefits under his mother's policy with Farm Bureau, and Farm Bureau denied the claim, taking position that the claimant lived with his father. Plaintiff Hurley Medical Center took an assignment of the claimant's claim and brought suit against Farm Bureau for reimbursement. Both parties filed cross motions for summary disposition, arguing that there was no genuine issue of material fact as to the claimant's domicile. Ultimately, the trial court granted Farm Bureau's motion as a matter of law and indicated and opined that claimant was domiciled with his father, and the action against Farm Bureau was dismissed. On appeal, the court noted that determining domicile is usually a fact question reserved for the jury. It's important to note here that the Michigan Supreme Court has generally recognized that young adults tend to be transient. They live with one parent, then the other, stay with friends, and sometimes struggle to find a home, or they may be back and forth from college and situations like that. So here the court balanced 9 factors on the actual question of whether the claimant in this matter domiciled with his mother or father. The court got these 9 factors from a combination of 2 cases, the Workman v. Detroit Auto Insurance case and the Dairyland Insurance Co. v. Auto Owners case. The first 4 factors are taken from the Workman case. 1 is the subjective or declared intent of the person seeking to establish domicile. 2, the formality of the relationship between the person and the members of the household. 3, whether that person lives in the same house, within the same curtilage, or upon the same premises. And 4, whether that person maintained another place of lodging. And in Dairyland, we go on to 5, whether the person continues to use his parents' address for his mailing address. 6, whether the person maintains some possession of his parents' home. 7, whether the claimant continues to use his parents' address on the driver's license or other documents. 8, whether a bedroom is maintained for the claimant at his parents' address. And 9, whether the claimant is dependent on his parents for support. Here, the court balanced these factors and determined that the claimant in this matter, 19-year-old man, was domiciled with his mother. He received bills and mails there. He maintained a bedroom at his mother's house. He left clothing and possession at his mother's homes. And the hospital records all listed his mother's home as his residence. And he also, respective to the accident, returned to his mother's home to recuperate. There was a fairly strong dissent by Judge Riordan, who concurred with the lower court. He opined that both claimant and his mother were interviewed after the accident by the Farm Bureau claims adjuster. They both denied that he lived at his mother's home, although it was indicated that he had a bedroom of his mother's home. At his mother's home, he received mail and personal property there. He also told the adjuster that he had not lived there since age 11. Taken together, this case is a good reference point for assisting adjusters in determining domicile in this type of situation, which I'm sure comes up fairly often. It also illustrates why matters such as these are not typically decided as a matter of law, but are left for the jury to decide to determine the conflicting issues of fault. And next up, we have the unpublished case of Melrose v. Nationwide, issued October 22nd, 2020. Here, the plaintiff suffered injuries in a 1984 car accident, including a traumatic brain injury, spinal injuries resulting in speech, memory, and executive functioning, and cognitive disorders. Plaintiff's physician in this case, her 34-year physician, prescribed attendant care at 12 hours per day, and due to the complex nature of her injuries, he prescribed the use of high-tech aides who are paid more than the standard attendant care aides. He also prescribed occupational therapy 6 to 10 hours a week and physical therapy and mental health counseling twice per week. Sometime after the accident, more recently, defendant had an IME done, which concluded that the attendant care and other therapies should be reduced. Plaintiffs, the longtime 34-year physician, argued that the reductions in these services would cause plaintiff great harm. When defendant made the reduction, plaintiff thereafter filed suit and included a request for a preliminary injunction asking the trial court, to order defendant to restore the benefits to previous levels for the pendency of the entire PIP suit. The trial court granted the injunction and ordered that defendant resume their prior payments, finding that plaintiff was likely to prevail at trial and she would suffer irreparable harm if the injunction was not granted. Thereafter, Nationwide appealed, and the Court of Appeals affirmed the trial court's decision on the preliminary injunction. To obtain a preliminary injunction, a litigant must show, 1, that there is no adequate remedy at law, 2, there is a real danger of irreparable harm, and 3, justice requires it. There's also 4 factors to consider in granting a preliminary injunction. 1, the likelihood that the party seeking the injunction will prevail on the merits. 2, the danger that the party seeking the injunction will suffer irreparable harm if that injunction is not issued. 3, the risk that the party seeking the injunction will be harmed more by the absence of the injunction than the opposing party would be by the granting of the release. And lastly, the harm to the public interest if the injunction is issued. And here you see the trial court and the Court of Appeals balancing these factors and ultimately deciding that the injunction was appropriate. Again, the trial court granted the injunction, Nationwide appealed, and the Court of Appeals affirmed the trial court's decision. And lastly, for our case law update, we have the case of Sterling Heights Pain Management v. Farm Bureau Insurance Company. This is a published decision and thus will be binding. In this case, the Michigan Court of Appeals held that no-fault insurers do not have standing to challenge whether a medical provider is properly incorporated or organized as a way of asserting that the services provided were not lawfully rendered. Pursuant to MCL 450-4904, Section 2, all members and managers of a professional limited liability company must be licensed to render the same professional services as the corporate entity. Here, plaintiff asserted that Farm Bureau did not have standing to challenge whether the services were lawfully rendered on the basis of a business licensing issue, and further argued that treatment itself was provided by licensed physicians. By way of background, Farm Bureau moved for summary disposition, asserting that the services provided by Sterling Heights Pain Management had not been lawfully rendered. Plaintiff's articles of organization revealed that it was organized for the purpose of rendering medical services by a licensed physician. Citing plaintiff's own 2019 annual report filed with Laura, Farm Bureau noted that 2 members and managers were not licensed physicians, which was a direct violation of the Michigan's Limited Liability Company Act. Essentially, Farm Bureau asserted that because neither the managers or the members identified in the annual report were licensed physicians, the treatment was not lawfully rendered and thus not compensable under the No-Fault Act. On appeal, plaintiff challenged Farm Bureau's standing to file, citing the Miller v. Allstate case, which resolved a nearly identical issue. In the case of Miller, the Michigan Supreme Court was asked to determine if treatment was lawfully rendered, where the healthcare provider was not properly incorporated. On appeal, Farm Bureau argued that Miller was inapplicable because the challenge was not to plaintiff's corporate form, but rather its organizational form, which violated the Michigan's Limited Liability Company Act mandates. The Court of Appeals ultimately held that the facts in this case were nearly identical to Miller, and for the purposes of standing, there was no distinction between a challenge to corporate form versus proper organization. Obviously, Farm Bureau was arguing proper organization. The alleged defect was different to that of an issue in Miller, was immaterial, according to the court. The court held that Miller controls this issue regarding standing to challenge proper organizational form, which similarly was vested exclusively with the Attorney General. The court also held that case law requiring compliance with the licensing requirements relative to whether treatment was lawfully rendered was irrelevant to the issue of standing to challenge corporate form. The court made a specific distinction and noted that Farm Bureau was not disputing that plaintiff as an entity was not properly licensed to perform treatment, nor that treatment was actually provided by a licensed physician, but rather arguing that Farm Bureau's sole challenge to the lawfulness of the treatment was concerned with an improper business form. Some big takeaways in this case are it's important to note that in evaluating whether services are lawfully rendered, insurance must be careful in how they are framing their potential dispute and their motions to avoid a challenge based on standing. Specifically, they have to purposely focus on whether an entity was properly licensed to provide treatment to the claimant or whether treatment was actually provided by a licensed physician and not just be concerned with the improper business form. Again, if the basis for disputing whether the services were lawfully rendered is premised on the lack of proper corporation or organizational form, the insurer will lack standing based on Miller. Obviously, these are very similar but two distinct issues to challenge to the lawfulness of services rendered. As for the trending topics in PIP litigation, today I wanted to talk about the MAIPF's recent decision that the 2019 auto reform changes to the order of priority took effect immediately. So they took effect back in June of 2019. As you all know, Michigan legislature passes a sweeping auto reform insurance bill that went into effect on June 11, 2019. It is effectively called 2019 PA 21. Some provisions went into effect a little later. We've done several podcasts, presentations, and newsletters about this issue. Not about the issue, but about auto reform. If you guys have any questions, I can of course, send you any of those podcasts or news lines that we have previously done. As you all know, the Michigan No Fault Act originally passed in 1973. No fault reform has been necessary to combat fraud, provide options for coverage for Michigan residents, and reduce the highest insurance rates in the country. And we are all familiar with the combat fraud and personally familiar with the highest insurance rates in the country. Under the 2019 reform, the priority rules remain the same for named insured and resident relatives. However, if the occupant of a motor vehicle does not have their own coverage or cannot seek coverage through a resident relative, they must now seek coverage through the MAIPF and not the owner/operator as it was with the old priority rule. So it essentially takes away that additional layer to get to the MAIPF. Obviously, this does not apply to someone who has opted out of coverage or has allowed their coordinated benefits to lapse without notifying their insurer per the statutory requirements. There's a small caveat, or it may not be a small caveat, but you must first become aware of whether they were inside of or hit by an employer-furnished vehicle or a vehicle for hire. These changes now direct certain claimants that did not have insurance of their own or through a resident relative to the assigned claims plan who previously looked to other insurance or the insurance of the involved motor vehicle accident for their PIP benefits. Although 2019 PA 21 states that it has immediate effect, on September 20th, 2019, the Department of Insurance and Financial Services, which I will refer to as DIFS from now on, announced through Order 19-048M that insurers could not rely upon the new order of priority until they revised their policy forms. And thereafter, the MAIPF adopted DIFS's position. However, Last month, the MAIPF did an about-face and reversed the course and formally acknowledged that the new statutory provisions took place immediately, as the 2019 Reform Bill states. According to the No-Fault Reform Bill, regardless of their effective date, amended provisions that affect the scope of coverage required to be provided under automobile policies may not be implemented until automobile insurers have submitted revised forms and rates for the director's new approval. So this blurb is what MAIPF interpreted to mean that the new priority rules could not be relied upon until the policy forms were revised. This created a ton of division between the carriers, especially between MAIPF and other carriers, where some accepted this provision and did not deny claims and continue to adjust them under the old priority rules, but others pushed back on the grounds that the No Fault Act's order of priority is purely statutory and does not flow from the policy terms. So no changes in the policy form should be needed to bring about the change of law. Here, Gilman v. Hastings, Secrets Water argued that Order 19048M exceeded the DIFS's constitutional authority, as DIFS does not write or interpret statutes. The MAIPF opposed Hastings' position in that suit. The MAIPF did come out with a fairly lengthy, almost 20-page bulletin highlighting this priority change and steps to move forward. Personally, I've had a few cases where this issue has popped up, and it seems as if the MAIPF is doing what they can, but insurers are battling and some are taking different positions. When I initially got the case I'm thinking about, I immediately thought that the no-fault reform took immediate effect and started preparing for a motion for summary disposition, and got all of my ducks in order, took the appropriate depositions to line up that plaintiff cannot seek PIP benefits from the insurer of the automobile, which is who I represented, but must first look to the MAIPF. The MAIPF was brought in, and recently when the MAIPF agreed that the order of priority took immediate effect, I was dismissed from the case. No need to file a motion. So that wasn't a good example of how it can be easy, but I'm sure there are some situations where the MAIPF may be pushing back and motions may need to be filed. In the MAIPF's bulletins, I highlighted some points which I thought were important. Here it acknowledges that based on the court's ruling, it indicated that the no-fault statute did not support the DIFS's order, requiring the MAIPF to only accept claims for which filings have been approved. The MAIPF is now notifying the director that it will no longer deny claims incurred post-June 11, 2019 at 3:22 p.m., for which the owner and/or driver's insurance was in effect on the date of loss, but the insurer had not received approval for revised filings. The bulletin also indicated that it will waive the 1-year back notice requirement for special circumstances, and is also making a limited exception to suspend the 1-year back requirement for those expenses submitted to the original insurer within 1 year of the date the expense was incurred, as opposed to requiring that this expense be submitted to the MAIPF or its servicing insurer within 1 year. I previously talked about the fallout and how the effect this has had on current litigated matters. As again, I'm sure that hopefully the MAIPF will be agreeable, like in my situation where it was easily decided and my client was dismissed almost immediately after this change took an effect. But some cases, you may have to file a motion, or I'm sure some insurers are assigning these claims to different carriers and trying to figure out where to take it from there. And that is all I have for the January 2021 episode of My PIP Monthly. Again, my name is Amber Rouse Holloway, and I am a partner here at our Troy office. Please feel free to contact me should you have any questions and or concerns. Thank you.